I'd like to do two things at the outset that will obviate the need to have a lengthy argument to the court. The first thing is I want to provide some authority to the court. The second thing I would ask for permission to do, if the court is okay with it, is to prepare a proposed order and maybe have it to you within 2 to 3 weeks that would cite some of the authority that's been provided to the court. That way I don't have to go through and give you all these successive citations in my argument today. I can just touch on some highlights and respond to some of the arguments that were made by the defense.
Well, I had already anticipated asking for proposed orders. I reviewed most everything and largely developing thoughts, but I would like the benefit of proposed orders before I finalize those thoughts. And so what you request is perfectly in keeping with that. 2 weeks is appropriate. Mr. Longman, how about for you?
I have no objection, Judge. That's how we anticipate forward with it as well, so we're glad to provide that as needed.
Well, I'd already given you all a heads up anyway to that effect.
As far as the timing of that.
I was going to look at the calendar because it's a holiday period.
Absolutely.
Let's do that right this minute. Give me a moment. Okay, 2 weeks from now, it's going to be, New Year's Eve. I know where I won't be.
I know where I'm not going to be.
Well, it's my anniversary. I know where I won't be. All right, so is the 8th, which is the following Friday, reasonable?
I think so, Judge. I don't know if the court would want us to have a citation to the record or anything like that. I don't know if the transcript's available to get done that quickly. I know our court also has a holiday, but if we get that ahead of time, that'd be helpful, but if not.
I've inquired, and I'll go ahead and tell you what the response has been. Apparently there are a number of requests for transcripts ahead of ours. It's not foreseeable that the transcript will be ready, as I understand it, until sometime in January. So it appears that we'll probably have to do proposed orders based on our recollection. Though I do know that there are a number of websites that do actually have some of the hearings that have been posted. So you might be able to find some of that testimony available to you online.
Wonderful. What concerns me is we'll be pushing up on the hearing date for the motions and limine. Brett, I know you got this set, didn't you?
22nd, January 22nd.
I don't mind waiting until the 15th. Well, no, I would like to have them at the latest by the 13th of January.
January 13th.
Yeah, because I would like to have the motions to suppress ruled upon before the 22nd, so that you'll have the benefit of that. Well, do you expect or anticipate anyway that will affect the nature of your motions and limine, what rulings I may make?
I presume your rulings that you make will affect everything we do going forward, Judge, so that's the best I know how to answer that question.
That's no answer. That doesn't know.
That's the best I have to give, Your Honor.
Oh, well, okay. Nothing's better than something that's not correct, so I'll concede that point. Then that puts us at the 13th.
We'll have it prepared by the end, Your Honor.
That work for you?
Yes, sir. Yes, ma'am. With that, I can keep my arguments relatively brief. The defense asserts that June the 18th of 2014 was the worst day in their client's life. No, June the 18th of 2014 was the worst day in young Cooper Harris's life, as he lay helplessly strapped in a car seat in the boiling heat of a parking lot at the hands of his father. The defense in this case suggested to the court that you must make some sort of historic decision here. I suggest to the court to the contrary. You need only look at history to see that your decision here is relatively easy. We would ask nothing more of this court than you follow the well-settled law that applies to searches and seizures in general, and specifically to the issuance, execution, and scope of search warrants. That authority has now been provided to the court in the binder that I've given the court, and I believe that authority covers most of the topics that the defense has now raised. I will tell the court at the outset that there are some factual assertions that the defense has made that we disagree with, and I think that's clear. But you're obviously responsible for recalling the testimony. I know that you've paid a great deal of attention to the testimony that's been presented in these lengthy hearings involving the motions to suppress. And I feel confident that we can lay out the factual basis to support the denial of defendant's motion to suppress, and that your recollection will be consistent with the proposed order that we plan on submitting to the court in conjunction with some pretty detailed analysis and fairly detailed findings regarding the applicable authority that should be applied in this case. Some factual assertions that I'll tell you that we flat out disagree with is first of all, the evidence is clear that police officers saw messaging from the defendant's phone very early on, and that messaging include inappropriate sexual relations with at least one other female. That was pursuant to search warrant that authorized just that. Reviewing a timeline of the defendant's day, which included who he was communicating with the date of Cooper Harris's death. A factual assertion that, quite frankly, was misstated just a moment ago, I assume just erroneously, involved, for instance, some Reddit posts, which actually came from a laptop and not from a cell phone. The evidence was that came from a Home Depot laptop. I also strongly disagree, the state disagrees, that the initial search warrants failed to set out a crime. Leaving a toddler strapped in a hot car in Georgia is always a crime. The question is it a malicious crime? Is it a criminally negligent crime? But it is always a crime to leave your toddler strapped into a hot vehicle. And when death results, murder charges are the potential consequence for that. At the very outset, as responding officers came upon this scene and found Cooper Harris in the condition that he was and the defendant roaming around on a cell phone, obstructing their ability to conduct their investigation and cursing at these uniformed police officers who were trying to give aid to this child. Had the investigation stopped there and defendant just said, "Lawyer, I want a lawyer," with nothing more than that scene alone, a crime had been committed. The question then becomes, was it a malicious crime? Or was it some sort of other cruelty offense, such as cruelty in the first or second degree, one of which might involve malice, and one of them might very well involve a criminal negligence? So at the outset, Your Honor, I think it's important for you to understand, and I know it's not lost on you, that responding officers and detectives in this particular case, as they found it the very instant they arrived on the scene, were involved in a homicide investigation. Of note, the defendant immediately began an attempt to obstruct that investigation of how his son came to be in the condition that he was. So, what facts you did heard that I think are uncontroverted. Police arrived June 18th, 2014. Cooper Harris is dead. He's laying on the concrete where the defendant had left him. At a minimum, at that moment, while the defendant is on the phone, we have, before uniformed officers, at a minimum, a negligent homicide. Whether that would later become, as it did, evidence of a malicious homicide was to be determined at that outset. The question at that point is why? Was the defendant distracted? Was there some sort of malice? What was the timeline for the day? How is it that this child came to be in the condition that he was? Why is the defendant on the phone? Why is he refusing to get off the phone, and why is he cursing at police officers who are merely trying to do their job? No apologies from the state or from the detectives or from the officers for wanting to find answers to those questions. There's no historic decision that needs to be reached here, Your Honor. You need only follow the well-settled law regarding Fourth Amendment and the investigation of these types of offenses to find that police officers were not only acting reasonably under the mandates of the Fourth Amendment, they were acting expeditiously and prudently to try to get answers to the questions that everyone had upon finding Cooper Harris dead on this scene, having been left in a car for a full day by his father. So, in their attempt to do so, the first thing the defendant does is it begins to obstruct them. Refuses to get off the phone to answer basic questions, steps towards an officer, begins to curse at one of them, finally begins to hang up his phone. At this point, they weren't sure who he was even talking to. It didn't take long for that responding officer to realize it wasn't 911, another important factor for police as they continue to sift through the known facts to figure out what's the timeline here, what exactly has gone on to lead to this poor young victim's death. The defendant could have remained silent but chose not to, and from that we gained some critical information that formed the basis of the initial search warrants in this case. He provided a timeline. He talked about a car seat. Suspiciously, he talked about recently reviewing videos of deaths in cars and seeing news reports about something that had happened to a similar person. He lied to investigators, claiming he had a good marriage and life. He also told police that this is his worst fear. What he failed to do, a glaring omission, is to mention that he had gone back to the car, a fact that was later proven upon review of Home Depot video that showed the defendant going back to the car midday to put some light bulbs in it. That's a pretty glaring omission from the interview that was not known at the time of the issuance of the first warrants, but later became known to law enforcement. Of note, and not lost on the court, I hope, is that police officers went to the defendant and said, "Hey, we have your phone, we've been charging it up. Will you give me the passcode?" And he consensually gave it. He didn't give a fake number. He didn't give. He didn't tell police, "No, I've been here too long." No reasonable person could take that request for a passcode to be other than, "Can I have consent to look on your phone?" There would be no other reason for police to have that passcode. And he consensually gave it to them at the outset from June the 18th of 2014. For the phone alone, we could probably just stop there. That alone would obviate the necessity for law enforcement to ever get a search warrant for his phone. But our police officers, who want to be prudent about how they conduct their investigations and want to be cautious, took the additional steps of saying, let's get a search warrant. We consensually got that passcode that the defendant gave us, that again was the proper passcode for the phone. No reasonable person could deem that to be a request for anything else other than permission to look on the phone. But they, out of abundance of caution, decided, hey, we're going to go get some search warrants as well. And those initial search warrants you saw at the outset did not have as much detail as the later search warrants. And it's a credit to law enforcement that they backed out when they found more information and decided that they would go back into these. So continuing on as a factual matter, after the obtaining of the initial search warrants and defendant's consent to look at his phone by way of him voluntarily providing the passcode to access it, totally independent of any search of the phone, you've heard victim CD contacted law enforcement in a roundabout way and indicated on the 20th, hey, I've been in a relationship, an inappropriate relationship with the defendant. Just from seeing that news report, she felt obligated to reach out to law enforcement. And independent of anything that had been done to that point, detectives then learned that despite the defendant's claims to the contrary, that he was happily married and things were hunky-dory at his house, to the contrary, there were all kinds of other things that were going on with him and other women. Based on that independent source, of course, law enforcement are going to seek additional search warrants, and those facts were actually included in subsequent search warrants. And you've heard repeatedly that detectives gave testimony that in subsequent search warrants after that date, they applied for additional search warrants to expand the scope of the permissible search, and included that they had learned, despite defendants' initial claims to being in a happy marriage, that they had learned independently, and admittedly in part from the phone, from some text messages from that day, that he was indeed involved in inappropriate sexual relations outside the marriage. Law enforcement, being prudent, of course they're going to go get search warrants. They've now found out that the defendant has lied to them. He's deceived them about an important fact, potentially covering up a motive for why he would have done what he did. All of these things, as they would delve more into them, omitting to mention the fact that he went back to the car, certainly provide evidence that this is appearing to be more malicious. And no apologies from the state and no apologies from law enforcement for them delving into that and applying for more search warrants and going to seek out whether that evidence is in fact true, as we've done here and as I anticipate we'll be able to prove. So more extensive search warrants were sought, and as evidence of the cautionary tactics of the police here, they even got search warrants for items they didn't have to get search warrants for, such as HR records or laptops that the defendant doesn't even own. He has no standing to contest the searches of those items. He arguably, admittedly, will have standing to contest the initial search of his vehicle where one of those laptops was found. Once law enforcement lawfully obtained that from the vehicle, he has no further standing to contest law enforcement's ability to search that laptop. It's not his. That belongs to Home Depot. In fact, Home Depot provided the encryption code for law enforcement to be able to get onto that device. So, the defendant has raised a number of issues. The first one that they raised is the warrantless phone seizure. I did put a tab in the notebook provided to the court. I did cite to court to Riley. US v. Riley stands for the limited proposition that you can't search a phone incident to arrest. It does not stand for the proposition that you cannot seize a phone. And Riley has never been read to say that there might not be other reasons that you can search a phone warrantlessly or otherwise under the right circumstances. Riley merely stands for the proposition that you can't search it solely incident to arrest. I don't think anyone on the state side, defense side, I don't think most judges would disagree with that opinion, that merely arresting somebody is not going to be a basis for being able to search a phone. I think US v. Riley is a rather sound opinion. But I will point out to the court, and it's included in the binder of authority that was provided to the court under the warrantless seizure portion, that there are two cases that are of note. One is the Hawkins versus State case. I disagree with the defense that it's no longer good law on some propositions. There is some question about whether it should be dealt with differently in regard to the search aspects, but not to the seizure of the phone aspects. In fact, if there's another case that's included in the binder, so I don't need to give the site, it's Brown versus the State, that was decided post-Riley and cites Hawkins in an affirmative manner, talking about instances in which a phone might be seized and then searched short of probable cause and short of incident to arrest. So Brown cites Hawkins affirmatively, does look at the Riley case, and does talk about circumstances in which it would be permissible to get onto a phone, even absent being incident to arrest. But here's the key critical case that I provided to the court. Smith versus the State, 262 Georgia Appeals 614 is a 2003 case. This was a felony theft investigation. Of note, at some time during this period where we had a detained suspect, one of the officers actually confiscated a cell phone as the suspect attempted to make a phone call. So we have, just as in this case, a detention. We have a defendant on a cell phone, and the police are saying, no, you're detained. We're going to seize that phone from you. So, take the search aside. They eventually, I think, got a search warrant for it. But the question there posed was, hey, is that initial warrantless seizure of a cell phone, is that authorized under Georgia law and under the federal statute? Let me read the applicable part to the court. It's short. It's on page 3 of the opinion that's been provided to the court. While the officers had taken her cell phone to prevent her from calling, the seizure of her phone was not in and of itself illegal, as it served the legitimate purpose of preventing an interference with the investigation. When the nature and extent of the detention are minimally intrusive to the individual's Fourth Amendment interests, the opposing law enforcement interests can support a seizure of person or property based on less than probable cause. That's exactly what you have here, Judge. We have 3 different bases that were articulated for the court on why this warrantless seizure of this phone was appropriate initially. First, officer safety. Second, probable cause. It was been instrumentality of an obstruction into the investigation of this cruelty case and potentially murder case. And third, because there was going to be a transport issue as well. Any one of those 3 legitimate purposes would fall under the Smith decision and would be permissible under the Fourth Amendment, and I think we've adequately shown that. So the initial seizure of the phone itself is permissible under Smith. It's permissible under the Fourth Amendment. You then get into the search of it, and that's a different matter altogether. We have a number of reasons that the search is appropriate, including consent. I will point out that there is an inevitable discovery component for the getting of a phone. Had they left the phone in the defendant's back pocket, you've already heard and seen evidence, partially in the Jackson-Deno hearing, where officers inventoried the items that were in the defendant's possession, and you heard testimony that the detective absolutely would have sought a search warrant, as they actually did in this case, for that phone, whether the defendant had that phone removed from him on scene or removed from him during the course of the custodial interview. So the warrantless initial seizure of defendant's cell phone, there's no problem there. Thereafter, the cautionary, most prudent course of action that police took was to obtain search warrants and consent, which they did. Once they got that consent, once they got the search warrants, it was permissible for them to look on the phone for whatever they wanted to, just pursuant to consent. But out of an abundance of caution, they also applied for search warrants themselves. I did provide a number of cases to the court on the legal standard for assessing the search warrants. I think that's important for the court to look at. And I won't give you all of the citations here, but I will point this out, that first of all, the motion has to be in writing and it has to be timely. I would suggest to the court, to the degree there have been any arguments that are outside of the scope of the 30-some page motion that's been filed with the defendant, they should not be considered. And Gomez and Conley cases provided to the court stand for that proposition. So what's the four-prong legal standard for assessing challenges to a search warrant? It can be found in ABRAHA, A-B-R-A-H-A, which is included in the motion to suppress authority tab of the binder that I provided to the court. And basically you do four things. First, magistrate court makes a practical common sense decision considering all circumstances that either contraband or evidence will be found. That's step one. Step two, the trial court then judges the magistrate court on a clear error standard. In other words, you sit almost in the position of an appellate court and say, all right, looking at the magistrate court, looking at both the oral and written testimony, written affidavits, search warrants themselves, is it clearly an error for the magistrate court to have issued any one of these search warrants? The answer is no. Then the next issue, part three, did the magistrate court have a substantial basis for concluding that there was probable cause for the issuance of the search warrant? And finally, part four, the reviewing trial court must give substantial deference to the magistrate court. So part four is that you should give substantial deference to the magistrate court absent you finding some sort of clear error here. So long as there's a substantial basis that there's probable cause for the issuing of these warrants, then you must give substantial deference to the magistrate court. The standard for electronic devices is no different, and there's a Blevins case that I provided to the court. All of the cases require that you look to the totality of the circumstances. The totality of the circumstances that were presented to the court, both in writing and the written affidavit, as well as in the oral testimony that was provided by the detectives. Looking at this legal standard, Judge, and just assessing almost as an appellate court must, you take the role of an almost appeals court in this situation, that there's no way that you can look at the search warrants that were initially issued and find that there was no basis, no substantial basis for the conclusion that there was probable cause. And to detectives' credit, what they did is as the scope of the search continued to grow, they said, let's not just work off the first warrants, let's go back and get permission to expand the scope. And I'm glad that the court was already referred to the Henson decision, because I provided it to the court as well. Henson's a very interesting case in that detectives were initially looking for drug evidence. It's 314 Georgia Appeals 152. It's found in the scope section of the binder that was provided. There, law enforcement had a search warrant for marijuana. They stumbled across child porn. What did they do? They stepped out. They said, we're going to go get another search warrant. Held. Records, electronic or otherwise, are a thing of permanence. And looking at analogous federal cases, they said this did not exceed the scope by backing out and getting additional search warrants. Almost the exact situation we have here. Law enforcement knew something at the beginning. that at a minimum this was a criminally negligent homicide, perhaps malicious. We want permission to go see whether there's evidence relating to the defendant's statements and potentially to child abuse and child neglect. During the course of that investigation, they then learn that there's more to this. They wisely seek guidance from our magistrate court by reapplying for search warrants, not to go and get new devices, but just to allow them to expand the scope of their search for motive evidence, which is perfectly permissible under the law. Henson says as much. The defense's claim that there are material misrepresentations in the applications. The state strongly disagrees. We can argue semantics about terms like research and things like that, but there has been absolutely no showing of any material misrepresentation. In fact, I'm not even prepared as I stand here to concede that there were inaccuracies. At most, there was a couple of search warrants where they omitted to put the charge in one place but left it in another place. And there's a case that I provided to the court that says that that does not make the search warrant a bad or subject to a motion to suppress. At most, at best, they may have shown that there is a minor inaccuracy, and there is a body of law that deals with that as well, and I provided it to the court. What the court is required to do is to take a look at it and see if, first of all, whether there's any intent to mislead. If there's not, you look at the totality of the circumstances. Where there's other evidence to support a given inference, it suffices even if there may be a minor inaccuracy. And then the court's permitted to excise any erroneous fact to evaluate probable cause. And you'll see that in the Bryant decision that I provided to the court. Judge, I'm not going to go through all the authority. I think I've covered that enough. I do want to just touch on a couple of points before I sit down. Yes, I think there is an independent source and inevitable discovery argument that applies to this case. That is not a gimmick, as the defense would argue. No, if there are 5, 10, 15, 100 ways to deny a motion to suppress, no apologies from the state for giving them all to you. And then whether you have them or not depends on the facts of a given situation. But here you happen to have one, an independent source, inevitable discovery argument coming from this independent victim that came forward and talked about this inappropriate sexual relationship that she was involved in with the defendant online. That alone would have allowed law enforcement to get the subsequent search warrants to get onto all of the electronic devices. You'll find that there's ample authority provided to you in the scope section, and I'll cite that in my proposed order to the court that talks about what limitations in scope are available. Largely, that's dictated on what they're searching for. The scope of the initial searches was indeed limited because of the information they had. And you heard that initially, once they dumped the defendant's phone, all they were looking at is the chronology of the text messaging and calls for that day, because that's basically the scope that they were in at that point, other than they had permission to go in and start looking for this video that they were trying to find. Of note, Judge, the actual searches themselves, all post-dated, not only getting the independent evidence, but also getting independent search warrants. So while law enforcement could have from the very outset used the initial search warrants to go on and look for these things, the actual searches themselves The actual searches themselves just happened to be were not conducted until after the independent source inevitable discovery and after the subsequent search warrants were obtained that were far more expansive in scope. Lastly, Judge, there are some standing cases that I'm provided to the court. There are actually some federal cases that look at the specific issue of work computers and work laptops and find that there is no legitimate expectation of privacy in a defendant for those work laptops, especially if there's an admonition, as in this case, that says, hey, this is property of Home Depot. And by you logging on to it, you need to understand that Home Depot's allowed to look at all your stuff. There are ample cases, federal authority and otherwise, that basically say you have no standing, you have no legitimate, reasonable expectation of privacy in that. So for at least a couple of the items we'll be talking about and addressing in our proposed order, we are going to address the standing issue. I think it's an important one, particularly for the laptop where the video was found that the defendant obviously saw involving deaths in a hot car where the vet was in that vehicle. That was a laptop that belonged to Home Depot. He has absolutely no expectation of privacy of that He may admittedly have had standing to contest the initial seizure of that from his vehicle, but that's satisfied by the fact that law enforcement had a search warrant. He has no additional standing to contest the subsequent search of it. Judge, with that, I think I've responded to what I need to orally. I'll prepare the rest of it and provide it to the court in our proposed order that will be submitted by the 13th.
I believe that concludes the business of the court today. I've heard evidence and arguments from both sides. Very much appreciate the quality of work and argument that both sides have presented to the court. I'll await proposed orders in January. I'll rule them shortly. I'll review everything in advance that you've given me, and my notes. And so my ruling should be before our next hearing on the motion in limine. And we'll be prepared to go forward at that time. Everyone have a good afternoon. We'll stand in recess.
We're in recess. We're in recess. Yes.